Dear students, Namaskar. Uh, Again, I'm going to touch important provisions of Article 19, which talks about the six freedoms subject to reasonable restrictions under Article 19 to 6. Under Article 19, Clause 1, Clause A, confers right to have information or to receive information. So, with regards to this right, which has been evolved by the judiciary because of the compelling circumstances. And here I'm going to discuss two case law which are little bit interrelated to each other. That case relates to right to vote. And all of you know that right to vote is a statutory right and it is also a fundamental right. So it's the voter's right to know or to have information about the aspirant candidates who will be elected by the voters, and it's the duty of the state to provide them all kinds of informations related to their antecedents, to their qualifications, to their status, so that they could cast their votes in favor of a good and stable, good and stable candidate who could, argue and defend their rights in democratic setup, either in parliament, central legislature, or the state legislature, as the case may be, or any other, you could say, any other systems like three-tier systems, you could say, uh, including Panchayati Raj. Here, for the purpose of having information about their candidates, a form, which was known as Association for Democratic Reforms. Here, Union of India versus Association for Democratic Reforms, where a three judge bench comprising Justice M.B. Shah, Justice P.V. Reddy, Justice D.M. Dharmadhikari held that the amended electoral reforms passed by the Parliament is unconstitutional as being violative of citizens' right to know under Article 19, Clause 1, Clause G, or sorry, Clause 1, Clause A of the Constitution. In this case, the petitioners for democratic reforms filed a PIL and requested the court for direction to implement the recommendations made by the Law Commission in its 170th report on 2nd May 2002. The Supreme Court delivered a judgment and directed the Election Commission to issue a notification making it compulsory for those who contest elections or who are the aspirant of elections to make a available information about their qualifications, about their education, about their assets, about their liabilities, and also about their criminal antecedents for the benefit of voters, because so that the voters could elect a accountable person, could elect a transparent person for the coming elections. The election commission acted upon the directions the directions or issued as per the issued notifications about the election commission with regards to the compliance. The notifications or directions issued by the honorable courts, election commission acted upon acted upon the order of the courts and issued the notification and making it compulsory to provide above information regarding education, regarding assets, regarding uh, regarding their liabilities and criminal incidents, that they should provide all these informations in their nomination form, so that the people could have knowledge or could know about all these requirements uh, which has been laid down by the Supreme Court, and it was made compulsory to provide all these information uh, 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 before filing their nomination for the contesting elections. And therefore, thereafter, what happened? The Parliament amended the Electoral Law, that is Representation of People Act, and negatived negatived the court's judgment and election commission notifications. Means that the Parliament, instead of acted upon the notification issued by the election commission because of the directions issued by the apex court, they have got amended the laws. Now, as and when this amendment was given to the People's Representative Act, and uh, the Parliament negatived the reports, negatived the court's judgment and notifications issued by the Chief Election Commission. Now uh, it's the PUCL moved to the courts, court challenging the validity of electoral reforms law as being violative of the rights, uh, citizens' right of information uh, under Article 19, Clause 1, Clause A of the Constitution. Because it's the Section 33 of Representative People's Act provided, notwithstanding anything contained in any judgment of any court or any order of election commission, no candidate shall be able to disclose or furnish any such information in respect of the elections. Because as we discussed that it's the Parliament which amended the RPA and negatived the court's judgment by providing the section 33, amended section of 33 of RPA Act. And in respect of the election, which is required to be disclosed or furnished under this Act or the rules made thereunder. So, thus the amended RPA Representative People Act provided that only candidates who are elected were required to give details of their assets and liabilities to the concerned presiding officers of the House and not the MPs who are not elected. So here that how very much intelligently and cleverly the Parliament passed this uh, amended this RPA so that they could hide the facts or hide the information about their education, assets, liabilities, and criminal antecedents. As you know that in amended act there was no indication that even for those who have been elected there was no indication uh, to disclose about their education and criminal antecedents. So the court, as in when it has brought to the notice of the Supreme Court that Parliament had amended the RPA and has negatived the judgment of court and the notification issued by the Chief Election Commission in the light of amended RPA. So the court held that Parliament had no legislative competence to direct the state or its instrumentality to disobey the orders of the court. The Parliament cannot declare that the law, the law declared by the Supreme Court, is not binding. Then all of you know that there is importance of Article 141 of the Constitution, which talks about that the decision of the Supreme Court becomes the law of the land and it's binding to all the courts and throughout the territory of India. So the court resorted its 2nd May 2002 uh, verdict and directed the election commissioner to issue a fresh notification for the implementation of the judgment. And keeping the amended RPA in mind, the court asked whether there was any necessity to keep the voters in dark about any murder, dacoity, or rape committed by a candidate or the aspirant who is going to contest the elections. But, and uh, also uh, that also that about that was there any necessity to keep the voters in dark about his ill-gotten money which could be used for election. And here Justice Shah said that the judgment was aimed at cleansing the democracy of unwanted elements, or you could say antisocial elements, and give the country a competent legislature. So the court said that the amended uh, RPA was a half-hearted attempt. How it was a half-hearted attempt? Because although the Parliament amended RPA, but the amended RTA was meant for their ulterior uh, self-interest or ulterior motives. So, because they did not indicate about the education, about the their past uh, antecedents or past their criminal history. So, that's why the Supreme Court remarked the remarked that the amended RP was half-hearted attempt by the government to fight the use of money and muscle power in election. So it was a very good judgment which had impacted the country's election reforms and also had sown the seeds for the present RTI, right to know, right RTI Act and the Right to Know the Information Act 2005, and that's why it was the government ultimately had to pass the RTI 2005. And here the here the norm set by the Election Commission for recognition of the state political parties also, although that for the recognition of the political party as a state party, the Election Commission order amending clause 6 of the election symbols order 1968 providing that the political party would not only have to score not less than 6% of the total valid votes polled, but it had also to return at least two members of the legislative assembly of the state was held to be valid. So it was benchmarks set by the election commission. It was not unreasonable. So in order to gain recognition as a political party, a party has to prove itself and to establish its credibility as a serious player in the political arena of the state. So you know that it is this PUCL case, which is the background of PUCL case lies in your Association for Democratic Reforms versus Union of India, and it's the later on the PUCL which had filed, which had brought into the notice of the courts, and the courts had nullified the amended RPA for the sake of the important right of the voters to have information or to receive information about the education, about the assets and liabilities and criminal antecedents of the candidates or aspirant candidates who is going to contest the election, either of the member of parliament or the state legislature. So it is one of the good decision which had given reforms in in the People's Representative Act as well as reforms in the Indian politics also. The next case, which uh, relates to Article 19 of the Constitution, although this case it is a Chintaman Rao versus State of MP. All of you know that the six freedoms given under Article 19 Clause 1 of the Constitution, uh, that is, all those are subject to the reasonable restrictions under Article 19 Clause 2 of the Constitution. And in case if the government is going to restrict the fundamental rights provided under Article 19 Clause 1 by unreasonable restriction, then that restriction will be declared as unconstitutional and that will be declared as illegal. So in this case, what happened? That this case is to be decided in the light of unreasonable restriction. So the that if the government which could pass a law, and a law authorized the government to, if the government means that the case was related to Chinta uh, Chintaman Rao versus state of MP. So it was the government of MP which authorized the government, or it was the law enacted by the state of MP, which authorized the government to prohibit all persons residing in certain area from from engaging themselves in the manufacturing of BD during the agriculture season. Means that they were asked to not to engage themselves in the manufacturing of BD during the agriculture season. And what was the object behind this provision? That the object of law was to provide adequate labor for agriculture purpose in BD making area. So the Supreme Court held the law is invalid as it imposes unreasonable restrictions on the BD making business of the area, and the act is much in excess of the object which the law seeks to achieve. So it not only compels those who are engaged in agriculture work from taking other employment or for taking other vocation, but also prohibits persons such as infirm, disabled, old women, and old uh, men and children incapable of working as agriculture laborers from engaging themselves in uh, the business of BD making and thus earning their livelihood. So, hence, it was arbitrary restriction, and it was totally or wholly unreasonable restrictions which was violating their fundamental rights under Article 19, Clause 1, Clause G of that particular people or of that particular citizen of that particular area of Madhya Pradesh. So you know that it is one good case which had been decided by the court in the light of the livelihoods of uh, small or deprived class which were engaged in video making, and they were earning their livelihood. And, so it was not only because in those days it was very old case, although nowadays we can say it's not only the violation of Article 19 Clause 1 Clause G, but also violation of Article 21, which you know that nowadays the right to livelihood is to be declared as a fundamental rights under Article 21 of the Constitution. Now another case which relates to Article 19, that is one case, and that is also very old case, that is the case of Narendra Kumar and others versus Union of India. And it was the case of 1960, although the writ petitions were uh, filed in 1959. What happened in this case? Uh, it was the case that the one restrictions, fundamental rights and restrictions, that again all of you know that in 1959 the people had two important rights under Article 19 of the Constitution. One was to be conferred under Article 19 Clause 1 Clause G, and another was the Article 19 Clause 1 Clause F, right to property. So here it was the tussle, it was the conflict between the fundamental rights under these two articles as well as the restrictions uh, imposed by the government. And here the rights restrictions, on such rights restrictions it includes provision of the law placing total restraint on the exercise of fundamental rights, constitutionality trade constitutional uh, and the constitutionality of trade in imported copper law, providing for fixation of price, means that here the government has fixed the price, fixed the fixation of price and issue of permits, resulting in elimination of dealers from such trades, and they cried before the court that it is the violation of their fundamental rights under Article 19, Clause 1, Clause G. And it the Essential Commodities Act 1955, and under Section 3 of Non-Ferrous Metal Control Order, and amended 1958, Clause 3 and 4 of Constitution, Article, and no, in this article we can say, on one hand, it was the fundamental rights under Article 19, Clause 1, Clause F, and the Article 19, Clause 1, Clause G. On other hand, it was the restrictions which were imposed by the government in the light of uh, 9, Article 19, Clause 5 and 19, Clause 6 of the Constitution. So, on different dates prior to April 1958, the petitioners entered into the contracts of purchase of copper with importers at Bombay and Calcutta. But before they could take delivery from the importers, the Government of India, in exercise of its powers under Section 3 of Essentials Commodities Act 1955, issued one notification on 2nd April 1958, the Non-Ferrous Metal Control Order 1958, Clause 3 of order provided that sell, no person sell, sell or purchase any non-ferrous metal at the price which exceeded the amount represented by an addition of 321% to its landed cost. While under uh, clause 4 of Impugned Act, no person shall acquire any non-ferrous metal except under and its accordance with a permit issued in this behalf by the controller in accordance with such principles as central government may from time to time specify. So such principles means that the principle which has been supposed to be specified by the government in the light of clause 4 of the Impugned Act. So no such principles, however, were published in the Gazette or laid before the two houses of the Parliament, though certain principles governing the issue of permits by the control were specified in a communication addressed by the Deputy Secretary to the Government of India, dated April 18 of 1958, to the Chief Industrial Advisor, by virtue of which the control could issue the permits only to the certain manufacturers and not to any dealer. Means that dealer has been removed between their from their uh, business. So on April 14, 1958, the petitioner applied for the permits to enable them to take delivery of the copper in respect of which they had entered into the contracts. As you know that they had made a contracts uh, with importers at Bombay and Calcutta, but the applications were refused. Thereupon, the petitioner filed a petition under Article 32 of the Constitution, challenging the validity of the order refusing the grant of the permit and contended, inter alia, uh, that the fixation of the price under Clause 3 of the Non-Ferrous Metal Control Orders 1958, which had the effect of driving the dealer out of business in imported copper and likewise. And Clause 4 of the uh, of the said order read with communication dated April 18, 1958 from the trade in imported copper. So, and all these all these provisions of impugned act are contravened or inconsistent with the provision of Article 19 clause 1 clause G and Article 19 clause 1 clause F of the Constitution. So that such total elimination of the dealer, uh, amounting as it will to the prohibition of any exercise of the right to carry on trade or to acquire a property. So was not a mere restriction. It was not a mere restriction on the rights. It was outside outside the saving provision of clause 5 and clause 6 of 19, means that all those were not to be saved or were not to be termed as reasonable in the light of Article 5 and 6 of the Indian Constitution, which talks about the reasonable restriction, because it's clause 5 and 6 of Article 19, clause 2, that the principles specified in the communication dated April 18, 1958, being discriminatory in nature as between the manufacturers and the dealer, because dealers has been excluded from the business in copper and infringed Article 14, Article 14 and 19, 19 clause 1 clause G of the Constitution, and clause 3 that said principles in any case had no legal force as they were not mentioned in the non-ferrous metal control order, nor were they notified in the official gazettes and laid before House of Parliament in the manner laid down in subsection 5 and 6, subsection 5 and 6, uh, uh, subsection 5 and 6 of section 3 of the Essentials Commodities Act. So it was found that the result of the abuse of the importers of the practical monopoly given to them of the copper market seriously affected the interest of the general public in India, and the impugned order legislation in the form of non-ferrous metal order and the subsequent specification of principles are made. Now that the what was held, the that the word restriction in Article 19 clause 5 and Article 19 clause 6, that where the restriction reaches the stage of total restraint of rights, special care has to be taken by the courts to see that the test of the reasonableness is satisfied by the considering the question in the background of the facts and circumstances under which the order was made, taking into account the nature of the evil that was sought to be remedied. Means that under Article 19 clause 5 and 6, the restriction has to be tested, has to be examined whether it was a restriction or it amounts to prohibition or amounts to prohibition. And sometimes that even it maybe amounts to prohibition depending upon the nature of the goods, which kind of goods are going to be dealt by the traders, or which kind of the goods are going into the trading activities. So, sought by to be remedied by such law, the ratio of the harm caused to the individual citizen by the proposed remedy, the beneficially effect reasonably accepted to result in the general public, and whether the restraint caused by the law was more than was necessary in the interest of the general public. So here, the court has referred the recent case, or you could say the case, but I have got discussed right now. The court has referred the case of 1951. What was that case? It was the case of Chintaman Rao versus State of MP, and another case is, it were the uh, Korji B. Barucha versus Excise Commissioner and the Chief Commissioner Ajmer and others, and the Madhya Bharat Cotton Association Limited versus Union of India, etc. So the court had referred the decisions of all these cases which were decided prior to the decision of this case of your Narendra Kumar. So that in present case the evil sought to be remedied, being the rise in price which led to higher price of consumers goods in the production of which copper formed a major ingredient. The fixation of price and system of permits for the acquisition of the material for reasonable restrictions in the interest of the general public. General public, that is clause 3. Clause 3 and 4 of Non-Ferrous Metal Control Order 1958 were accordingly reasonable restriction within the meaning of Article 19 Clause 5 and Article 19 Clause 6 of the Constitution. That the differentia, second, that the differentia which distinguish dealers as class from manufacturers placed in other class had a reasonable connection with the object of the legislation, and consequently the principle specified in communication dated April 18, 1958 did not contravene, contravene Article 14 of the Constitution, and that's why that cannot be held to be discriminatory. And that the clause 4 of the non-ferrous metal order was not effective without the principles of specified by the central government in the manner laid down by the section 5 and 6. So the essentials, uh, so the clause of the Essentials Commodities Act, as the principles specified in the communication dated April 18, were not notified in Gazette nor laid before both houses of the Parliament as required by Section 3, subsections 5 and 6 of the Act. Clause 4 could not be enforced. Accordingly, the Clause 4 of Order, as it stood, was void till such time as the principles are published in accordance with Section 3 and in the light of Section 3 of subsections 5 and 6. And in this manner, it's the courts which has disposed of this writ petition, saying so that the petitioners are therefore entitled to relief only in respect of clause 4 of the order, and we direct that an order be issued restraining the respondent from enforcing clause 4 of non-ferrous metal control order so long as principles in accordance uh, with law are not prohibited in the official gazette and laid before the House of the Parliament in accordance with subsections 5 and 6 of clause 3 of section 3 of Essential Commodities Act. So as the petition, we could say the petition has succeeded in parts and failed in part. We can say that that we order the order that the parties will bear their cost and petition partly allowed, means that it was not wholly allowed, rather because that the petition has succeeded in part and failed in part. So the it was the case of Narendar Kumar in the light of Article 19 Clause 1 Clause A, and also in the light of Article 19 Clause 5 and Clause 6 of the Constitution, which talks about the reasonable restrictions to the liberties under Article 19 of the Constitution. So, as indicated by few students, that I have not covered Syria single, I have got covered it earlier. PUCL versus Union of India, I have covered it right now. CPIM, I have got covered yesterday. AIDMK versus Chief Secretary, Government of Tamil Nadu, case of 2007, which was related to 136, Article 136 SLP, because the interim order of Tamil Nadu or Madras High Court was challenged challenged before the Supreme Court under Article 136. You know that is rarely the Supreme Court awarded the relief, but it depends on the circumstances, because that is very important and residuary power of Supreme Court. Chintaman Rao versus State of MP, I have got covered right now. Narendar Kumar, we discussed right now, and this Tehseen S. Punnuwala, I discussed yesterday. Now, another important case law, although I have got covered it, in case if the students are able to recall, once we had started to discuss Article 14 of the Constitution, and once we were talking about the reasonable classification, that equality among equals, because that although Article 14 talks about the principle of equality, but for the sake of access to justice, access to justice, the Supreme Court, access to justice, the Supreme Court have got propounded or have got expanded and propounded the meaning and content of the word person under Article 14 of the Constitution. As all of you know, okay, what Article 14 says, that Article 14 says, or 14 declares, that the state shall not deny to any person equality before law, or the equal protection of laws within the territory of India. So here the word person, has been the person has not be is not going to be denote whether the person is the male or female, or neither he or she is male or female. So in case, and that's why, for the protection of the rights of the rights of the person who are neither male or female, it's the National Legal Services Authority which filed a petition before the Supreme Court, and or that this was filed before the the final decision was decided before the Supreme Court, and here that case was related to the transgender. And in case if you are able to recall, that I have discussed when I had discussed Article 14 of the Constitution. However, I will be give the repetition to this case also. So, in this case, it was the Supreme Court. Supreme Court has held that Article 14 does not restrict the word person and its application only to male or female, only male to or female, and transgenders persons who are neither male nor female fall within the expression of the word of the expression of the person under Article 14 of the Constitution. Means that now the Supreme Court allowed that under the expression of person under Article 14, those who are neither male or female, they can also be included. Uh, 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 they can also be uh, covered, and they could not be denied the right of equality. The right of equality, and they will be entitled the protection of equality or equality before law and protection of laws or protection of equality if, by from the laws. So here they are entitled to legal protection of laws, legal protection of laws in all spheres of state activity, including employment, healthcare, education, as well as equal civil citizenships right as to enjoyed by other citizens of the country. So the expression sex, dear students, sorry that this case law was not fully recorded. So I would try to connect it. I'm going to connect it with my last statement or last. So we were discussing that it the in the light of this judgment which relates to transgender, the expression sex under Article 15 and 16 therefore includes discrimination on the ground of gender identity. So the expression the expression sex is not limited to the biological sex of male or female, but it intended to include people who consider themselves to be neither male nor female. Transgenders have been denied right under Article 16, Clause 2, and discriminated against in respect of employment or office under the state on the ground of sex. They are also entitled to reservation in the matter of employment or appointment under Article 16, Clause 4 of the Constitution. So that's why if the state is bound to take affirmative actions to give them their due representation in public services. Article 14 has used the expression person. Article 15 used the expression citizen and sex. Also, Article 16 art, it's also Article 16 which used the word sex. Article 21 has used the expression person, and these expressions which are gender neutral, evidently all these either the expression person is gender neutral. So that's why being gender neutral, it evidently refer to the human beings. Means that the person does not specifically talk about the male or female. The person, the, the expression person evidently reflects itself that it is uh, gender neutral, and that's why it reflects or it's referred to human being. The human being means that either he is male or she is female, or neither he is male or female. Means that in case if someone is third gender or transgender, then that can also be included, that can also be covered under the ambit of the expression of person. So hence they take within their sweep, means that hence the under the expression a person takes within their sweep transgenders, hijras or transgender are not as such limited to male or female gender. And it's the court made the following declaration that if the hijras ranches apart from binary gender be treated as third gender for the purpose of safeguarding their rights under Part 3rd of the Constitution and the laws made by the Parliament and the state legislature. Transgender right to decide their self-identified gender is also upheld. The centre and the state government are directed to grant legal recognition of their gender, identified such as male, female, or third gender. Means that it depends on their own speech whether they would like to call them Gita or Mohan or transgender, male or female or transgender. So we direct the center and the state government to take steps to treat them as socially and educationally backward class citizens and extend all kinds of benefits or all kind of special provisions in cases of admission in educational institutions and for under article 15 clause 5, sorry, under article 15 clause 4 and under article and public employments under article 16 clause 4. Central and state governments are directed to operate HIV zero surveillance centers since hijra or transgenders face several sexual health issues. So that's why they are directed to operate the separate HIV zero surveillance center for the cure for the curing of this class of transgender. Central and state governments should seriously address the problems being faced by transgenders, such as fear, shame, gender dysphoria, social pressure, depression, suicidal tendencies, social stigmas, etc. Central and state government should take proper measures to provide medical care to transgenders in the hospitals and also provide them separate public toilets and other facilities. Central and state government should also take steps for framing various social welfare legislations, social welfare schemes for the upliftment and betterment of transgenders. And the central and the state government should also take measures to regain their respect and place in the society which once they enjoyed in our cultural and social life. Now, the another important case law which relates to Article 19, Article 19, Clause 1, Clause G, and Article 37 of Constitution, and in the case of State of Gujrat versus Mirzapur, Moti, Qureshi, Ksab, Jamat. Dear students, I have got referred this case earlier also. Once I discussed Article 25 and 26, and also once I have got discussed the provisions of relation between directive principles and fundamental rights. In this case, uh, it was the government of Gujarat which had put a ban on the slaughter of cows and its progeny in the state of Gujarat. And in the light of one act, enacted act, that was the Bombay Animal Preservation of Gujarat Amendment Act of 1994, which had prohibited to slaughter or to slaughter cows and progeny. So here the petitioners, who are the butchers and they were running the slaughterhouse for the, for slaughtering the animals, including cows and her progeny. They had challenged the constitutional validity of this impugned acts on the ground that it is the violation of their fundamental rights to carry on trade and business under Article 19, Clause 1, Clause C of the Constitution. Under the above legislation, the Gujarat had, as I would mention, the Gujarat government had uh, imposed a total ban on the slaughter of cows and calves and its progeny. The seven judge constitutional bench of the Supreme Court, because the appeal was made by the Supreme Court from the decision of the High Court, and the Supreme Court by 6-1 judges majority, seven judges bench, and it was the majority of 7-1. Sorry, 6-1. Following its number of earlier decisions, like Hanif Qureshi versus State of Bihar, in that also, uh, there was ban on the slaughter of cow and its progeny. And Mr. Hanif Qureshi had claimed that it was the violation of his fundamental rights to sacrifice a cow on Bakra Eid. But the Supreme Court had not allowed and restricted that right under Article 25 and 26 of the Constitution in general public interests. And here also the Supreme Court, by following its early decision, uh, held that the earlier decision and in the light of directive principles which are relevant in considering the reasonability of restrictions imposed on fundamental rights. And the Supreme Court argued that it is constitutional mandate under Article 37 of Constitution, which provide that in formulating the policies and making the laws, the state shall apply the directive principles. The restriction placed on fundamental rights will be held reasonable and hence valid, subject to only two limitations. It does not conflict with the fundamental rights, and the concerned legislature is competent to enact it. The court held that the prohibition on slaughter of cow and her progeny does not amount to a total ban on business activity of butchers. Means that they have been prohibited to slaughter the calves and its progeny. They have not been prohibited to slaughter other animals or other cattle. So they are left free to slaughter cattle other than those specified in the act or specified in the act, depending on slaughter of cow progeny is not a prohibition but only it's a restriction. It's not total prohibition. Total prohibition to article or the right under article 19 clause 1 clause G of the constitution. So only a part of their activity has been prohibited. The cow and her progeny constituted the backbone of Indian agriculture and rural economy, as the cattle products and drought animal power in the field of nutrition and health, agriculture and energy like biopesticides, biogas plants, and organic farming. So, in the view of this, government felt that it is necessary to formulate measures for their developments in all possible way as to prevent their slaughter, because it was necessary to formulate necessary measures for the development of this particular cattle, that the cow and its progeny, and that's why the possible measures have been introduced to prevent their slaughter. The ban on slaughter of cow progeny imposed by the Act is therefore in the interest of general public within the meaning of uh, clause 6 of article 19 of the constitution. So in this manner, again we can say that uh, the court had given a harmonious construction to the both the impugned act in public interest or in general public interest, and the interest of fundamental rights under Article 19 clause 1 clause G, because the court had indicated that they have not been uh, totally exhausted from the from the business of slaughtering of cattle. They have been prohibited only to not to slaughter the cow and its progeny. So it's all about this uh, case, which was related to Article 19 and Article 37, as well as other provisions of directive principles, which talks about to protect the wildlife and to protect the animal husbandry also. So uh, it was the case which was decided by the Supreme Court for the and upheld the validity of the Impure Act, which was meant for banning the slaughter of cows and its progeny. Now, uh, another case which was related to Article 22. Article 22, although I have got discussed this case, in case if you are able to recall that discussed we once we discussed Article 123. Article 123 relates to ordinance making power by the president. Here, it's and this case is also covered under under Article 22 of the Constitution, which talks about the safeguards against arbitrary arrest and detention. As under Article 19, Article 22, there are the two kinds of safeguards to the arrestee person or detainee. It's Article 22, Clause 1 and 2 talks about the safeguards extended to the accused person, extended to the arrestee person in under ordinary laws or ordinary criminal laws. But Article 456 they talks about the safeguards for the detainee detained under preventive detention laws. And as we discussed, you know that we are having a lot of preventive detention laws, and out of that, one was or uh, one is the National Security Act, and this case is also A.K. Roy versus Union of India, popularly known as National Security Case, and the Supreme Court by majority 4 to 1 upheld the constitutional validity of National Security Act and Ordinance which preceded the Act, and the court held that Act was neither vague nor arbitrary in its provision, as providing for detention of a person on certain grounds as acting in a manner prejudicial to the defense of India. Means that in case if someone person is acting uh, prejudicially to the defense of India, security of India, or security of the state, and to the relation of foreign powers, while upholding the validity of National Security Act and ordinance, or in ordinance preceding it, the court issued a number of directions also with a view to extend the safeguard or with in the interests in the interest of the detainees detained under the National Security Act. The court directed that first that immediately after detention his kith and kin must be informed in writing about his detention and his place of detention. So the detainee must be detained in place where he habitually resides. Means that preferably he should put under detention, preferably where he ordinarily resides or at his home, unless exceptional circumstances require the detention at other place. Third, the detainee is entitled to his book and writing, means that he won't be disallowed. He won't be disallowed for reading his books or for writing his material, and for his own foods, visits from friends and relatives, and he must be kept uh, separate from those convicts or from those convicted prisoners, and no treatment of punitive character should be meted out to him, and he should be treated according to the civilized norms of human dignity. Means that even after even after preventive detention or put in detention, he could not be deprived from his fundamental rights, the right to live with human dignity under Article 21 of the Constitution. And here, because all of you know that it was the uh, government which had, although government had amended the law, but the majority amended the law by 44th Constitutional Amendment. The majority, though disapproved the delay on the behalf of government, is not bringing into force the 44th Constitutional Amendment, but held that it could do nothing. It said that the power to amend the Constitution is different from that of bringing the concerned amendments into force. So the 44th Amendment itself left it to the central government to bring the amendment into force by a notification. Since it had not been brought into force, it does not form the part of constitution, and therefore the National Security Act is valid even though it does not provide for the setting up of advisory boards in accordance with the amendment. And here Justice Gupta and Tulja Purkar justice dissented from the majority on this point and issued a mandamus to the union government to bring the amendment into force. So it is submitted that the minority view on this point is correct. The amendment must be brought into operation within a reasonable period or within a reasonable time by the government. So it would appear to be anomalous or anomaly that Parliament can pass an amendment and which cannot be brought into operation at all. So Section 3 of 44th Constitutional Amendment was intended to be safeguard against the misuse of the power of preventive detention by the government and provided for the setting up of the advisory boards or advisory bodies, which would be a much more independent and impartial body. By not bringing into force the provision of 44th Constitutional Amendment, the central government had not performed its constitutional duties, and the majority have abdicated its power to issue a mandatory direction to the government to bring the amendments into force. So, thus, the petitioner was denied a very important right, that is, the right to have his representation considered by a board as set up in accordance with the provision of 44th Constitutional Amendments. So, it was the case of Ekiroy versus Union of India, which was related to Article 123 as well as it was related to Article 22, which talks about safeguards against the arbitrary arrest and detention. So it's all regarding uh, today's discussion, and that the rest will be discussed